defense is arguing here. Introduction, glad to have back with us Jason Friedman, coming to visit again, a former prosecutor in the Brooklyn DA's office, currently a civil trial attorney. Jason, good to have you back here with us. Hold on for 1 second for me, if you would. So, the defense has offered up this defense of self-defense, and the defendant has decided to take the stand to testify in his own defense, in his own words, describing what it is he said happened that caused him to take the life of Dan Sorensen. Let's listen to some of the details he offered up to this jury.
Did there come a time when he pointed that gun at Leckerman?
Yes.
And did he point the gun at you?
Yes.
And as a result of that, what did you do?
There was a knife on the tool, I don't know, it's like a tool bench, and it was a kitchen knife, it was like a paring knife. I grabbed that and went over behind Dan, and I was like about a foot from behind him. And I said, Dan, don't. And he looked at me from the corner of his eye, and then he like went, like he straightened out his arm like he was going to shoot Alex right in the face. And I kind of grabbed him with my left arm and stabbed him in the back at the same time, and we fell to the ground.
All right, Jason, so we're watching and listening to this, and it's really extraordinary. First of all, as you know, you don't often get to hear a lot of defendants take the stand and testify in their own case. It just doesn't happen that much. In this case, given the facts here and given the defense of self-defense, did he pretty much have to testify?
Yes, Jack, he had to testify here, especially when there's no independent testimony, evidence, eyewitness to support the case of self-defense. Compare the situation where if this happened out in public, out on a street corner, there's some independent bystanders, witnesses that can talk about that, yes, this defendant was acting in self-defense. Here, we don't have any of that, and conversely, we have the other people who were there testifying against this self-defense. He absolutely had to testify in his own defense if he had a chance, if he has a chance to get off on this case.
What do you think about his appearance here? I don't know if you heard us talking about it before, Jason. I was likening it to times, I don't know if you've ever done this yourself, where, you know, high schools do these mock trial, they have mock trial teams that get out there, moot court teams. And I said, looking at him on the stand, I had a sense that I was looking in on one of these high school moot court appearances. Do you think the juxtaposition of his appearance with these horrendous facts somehow can help him in his case?
I think at first blush, possibly, because he is, as we've been saying, baby-faced, you know, rose-cheeked. However, as soon as he gets into his testimony, I think all of that goes by the wayside, especially notwithstanding the murder. This whole plan to extort $500 that was supposedly stolen from him. And by the way, did you notice that he said, I have money, money's not the problem? So as soon as he starts talking about this whole plan to begin with, I think quickly we get out of our minds that he's so baby-faced.
That's a good point, and you get us nicely to our next part of the discussion here, and that is essentially what the prosecution is arguing. They're saying, you know what, the circumstances around this, they just don't fit the facts that he's offering up here as his defense. Listen to some of the testimony, some of the cross-examination of JP Orlewicz here.
So you decide that you have to get rid of the body, right?
Yes.
You have a cell phone on you at that point, right?
Yes.
You could have called 911, right?
Yes.
You could have called the police, right?
Yes.
Police would come. You would tell them that this guy tried to hurt you, right?
Yes.
You would tell them that he had a gun, a loaded gun, and he was going to kill you and your friend, right?
Yes.
You would tell them that it's self-defense, right?
Yes.
But you didn't do that, did you, Mr. Orlewicz?
No.
All right, so Jason, let's talk about that. I'll take you back to your prosecutor days here. And this prosecutor is starting to highlight a number of those circumstances that are sort of floating around the periphery here. What do you say to the jurors about some of these facts when you say to them this was not a self-defense?
Right, what he's doing is eliciting all this other testimony to really eat away at the credibility of this defendant. His credibility is the only thing he has going for him if he hopes to carry the day in his own self-defense. And I think by talking about his conduct both before the murder and after the murder, he's just saying to the jury, I bet he's going to say it in closing arguments, that it just strains credibility. It just goes too far beyond the pale for any reasonable person to take what he's saying seriously.
One of the things that the court did here is they limited, and the defense, I'm sure, would say significantly limited, how much the jury was going to hear about the victim in this case, Dan Sorensen. And some of our viewers have had questions, especially about these restraining orders that had been placed on him previously before this. There were, I think, 4 of them altogether. The judge essentially said, I'm not going to allow the jury to hear this because there's no proof that JP Orlewicz knew anything about those. Does that sound like the right approach to you, and why?
I think it is, Jack, and this is something that comes out in almost every trial where you know, this is an issue, and a lot of times it becomes an appellate issue as well. But ultimately, the state of mind of the defendant is paramount, and regardless of the prior bad acts of the victim in this case, if the defendant doesn't have knowledge, how are you going to argue that that affected his state of mind when talking about this particular crime? In this case, I think the judge made the right decision from the evidence that I'm aware about.
Yeah, and that's a good point in terms of the argument that the prosecution made and the argument that the judge agreed with. Jason's going to stay.
Thought you had to.
Yes.
You stabbed him in the back and continued to stab him even though he didn't have a gun because you felt threatened.
Yes.
The truth of the situation is that you were in control of the situation, Mr. Orlewicz, isn't it?
No.
You were the one who invited Dan Sorensen to that location not once but twice, right?
Actually, Dan invited himself the second time.
Well, you were the one that hatched the plan and the location and invited him over, and he came over not once but twice, right?
Dan hatched the plan. Dan chose the location. I okayed it.
Okay.
That's what it sounds like when you're speechless. And I have to be honest with you, 20 years of broadcasting, and this one really does leave me speechless. Every single time he opens his mouth on the stand, I am speechless. So could you please fill the void for me, Jason Friedman, and explain to me how it is that this is somehow a defense in a court of law? I don't get it.
Very simple, Ashley. It's called grasping at straws.
Oh, that's that really strong legal expression that you guys use in law school?
Exactly. What else are you going to do? You have nothing else to do here. And I really do agree with you how great Mr. Moran is doing on cross-examination, and for several reasons. You know, what he's doing is what we call slicing it thin. He's asking a series of very short questions, sometimes asking the same question more than once. He is, you know, the tone of his voice, sometimes incredulous, sometimes a little sarcastic without going too far. And most importantly, he's using the defendant's own words and answers to the questions. He's throwing it right back at him. And it's just very, very effective. I get the feeling that I'm watching a ship take on water and getting lower and lower and lower. And it's almost sunk as far as I'm concerned.
You know, it's funny. I was thinking something else. I was thinking mincemeat. That's what I was thinking. I mean, you're right. I just think that Robert Moran is just unbelievable. And it's I hate to say it's enjoyable to watch, but it is enjoyable to watch when somebody's really good at his job and doing a really good job. Hold your thought for a moment.
Well, prosecutor's closing argument here. Jason Friedman is our guest throughout the course of our day today. So, Jason, are you hearing from the prosecutor what you'd expect to hear in this case?
Oh, absolutely. He's going to slowly, methodically go through all of the evidence, highlight to the jury all of the things that just don't make any kind of sense to any kind of reasonable person. He's using a lot of the quotes that were given on the witness stand, as well as the evidence that were produced at the trial, and just, you know, slowly going through everything to, you know, finally culminate to say it just doesn't make any kind of sense. You obviously have to find this person guilty. I've proved my case beyond a reasonable doubt.
Let me ask you one question about the defense closing argument, because we're going to get to that in just a moment here. If you're the defense attorney, are you willing to essentially give up on the charge of the mutilation of the body afterwards and be happy if the jurors are able to say, okay, we're not so sure about the self-defense, so maybe we'll say not guilty about that, but they've even admitted that he burned the body, cut the head off. Right. Are you willing to give up one in return for a shot at the other?
You are, and for two reasons. Number one is, first of all, there's no equivalent to self-defense when it comes to mutilating a corpse. But number two, it's for credibility. You want to establish that credibility with the jury, so you're going to make a concession and then ask them, obviously, to find in your favor for the main question. You know, it occurs to me that as I was sitting hearing this, and I remembered the Durst case, and you know, these defenses actually can work. So I think the prosecution's case is very strong here, but sometimes it works.
Yeah, the defense certainly has something to talk about. We've seen in the past, you'd see Robert Durst, who actually got a favorable verdict in terms of the murder charge and was found guilty, responsible in terms of the dismemberment and the body mutilation charge. And maybe that's indeed what the defense is looking for here. Well, here's what we're going to do. We're going to fit in a
defense past a jury these days. Would it have been absolutely impossible in this case?
I'm sure that the defense attorneys contemplated that and seriously considered it, but you know, we've talked about this before. Sometimes it's just not there to be had in terms of the defendant's prior psychiatric history, if any. They might have had him examined, and it just didn't pan out. It's, as you said, it's a very, very high burden. And let's face it, this defendant testified in his own defense, and we've seen a lot of other defendants in a lot worse shape, and still not to be able to carry the day for an insanity defense.
Yeah, Michael Mucko saying that he did it for Hitler, if I recall correctly, when he got on the stand. Hey, Jason, great work from you today. I really appreciate you coming in to talk to us, and hope you'll come back and visit us again.
Thank you.
All right.